Mention from 52. Item 52. The last one take the LCR and get the
What happened?
some time for
Once you will take a file, thereafter you prepare, what is this? 52. Oh, 2007, huh? Okay.
My lord, item number 51. I pray,
Yes.
my lord, let it be taken up after lunch. That
Okay.
matter which I was arguing. After lunch, my lord.
Okay. Okay. Yes.
36. Item 36.
36. Okay. Let us see. Let the report come. I'll just. Sorry?
Yes.
Report. Let us see the report. Let the report come. I'll accommodate. Don't worry. Huh? Yes. Oh, nothing. Yes.
Item 1.
Also, in this case, IIT is in VC also.
Yes. Who is that? Mr. Khora. What is your name, sir? What is your name? Unmute. Unmute.
सर नमस्कार सर सर कान्हूचरण स्वाई
Kanucharan?
स्वाई
Kanucharan, fine. Okay. Have you seen the application?
सर
What is your take? What do you say?
सर डायरेक्शन मत थिला जो जे कोन पई की अकाउंट डिफ्रीज करा हैची पिटिशनर फ्रीज करा हैची
No. Problem is earlier the direction was to furnish bank guarantee. Okay.
सर
Then he moved an application saying that bank guarantee cannot be furnished because all of my accounts are frozen.
सर
Therefore, he said that I will give property security. The court modified it, saying that
Sir.
okay, you give property security.
सर
Thereafter, now an application is moved by the complainant or temple of this thing, saying that no, he should file the bank guarantee only.
सर
So if he doesn't have the bank account which are frozen, practically it may not be possible for him to file bank guarantee. So he is giving property security. What is wrong in it?
सर प्रॉपर्टी जो प्रॉपर्टी सिक्योरिटी पई की हम टेंपल एडमिनिस्ट्रेशन फाइल करछन जे आईए माध्यम रे जे सेटा डिफिकल्ट हबा हम पई की
I am not concerned about him. You have to tell, being the IO, that
Sir.
whether it is the proper security or not. Temple management say whatever. It is now investigation is going on. You are the IO. You have to tell us. Let the complainant say whatever. I am not bothered. Have you verified the property security who is offering? Have you verified?
No sir, petition neither petitioner or temple
See, I'll
administration.
tell you, he is yet to face the trial. You can't presume that he has committed the crime. It is only for the purpose of security, the amount, and he is offering property security. You just verify it. Why are you not verifying? Have you verified it?
Property security साहब verify करना है sir.
That is your job. You should have verified. You can't presume that he has committed the crime, and with that prejudice mind, you can't say that no, everything has to be deposited. Tomorrow he may be acquitted also. Who knows? So
Sir.
today he has a presumption of innocence. So therefore you can't insist someone to give bank guarantee, particularly when the accounts are frozen. That's the reason I have modified it to the property security. Your job is to just verify the property security which he is offering is adequate or not. That's all.
Sir,
If it is adequate, we will go ahead with this. If it is not adequate, then tell us, no, this is not adequate, this property is encumbered or something of that sort. Did you follow what I'm saying?
sir, followed, sir.
You do it, it is between you and the court now. I'm not going to hear them because you are the investigating agency, you have to be satisfied.
Sir,
Okay.
sir,
So when can you do it next Tuesday and tell me?
sir, require 1 week, sir.
No, 1 week only I'm giving. Okay, Thursday, next Thursday. You verify the property which is offering to give the security, whether it is adequate or not, tell me. If it is not adequate, then we will think how to go about it. Okay?
Sir,
Please do it on Thursday, next Thursday.
We have given along with the documents, valuation report.
Valuation report and document, everything he has given. Just look at it. If it is satisfying the security, then it's all right. If it's not satisfying, then we'll think of if it's undervalue or anything of that sort. He has given the valuation report also.
sir.
Please do that and tell me next Thursday.
Sure.
Okay, next Thursday. Keep it in
Sure.
next. Yes. Next Thursday. So and so appear. So and so appear. Not legally. Not the koi thing. Appear. Persons to the order dated so and so. Last order like the person to order so and so. And he sought 1 week time to verify the property security, the authenticity of the document, valuation report of the property security offered by the accused person to satisfy the security. Satisfy the security. Release the matter on Thursday. Okay.
Item 2.
Item 2 goes.
For extension, so
Not press. Okay, not press. 901, 909, not press. Why? Got arrested? Very good.
Item
Yes.
C.
This is first time you are seeking or? Okay, extension. Video. 15th October? 15th October? No further extensions shall be granted.
Item 4.
The property.
Withdraw. 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 Yes.
Item 5.
Why? Yes, Mr. Padi. You physically present, mentally somewhere else.
I think my number is 6. Extension of time for second time.
Second time. Why? Why second?
No.
Initially, it was given, March.
Yes, sir. Chutti thila. That's why I say, once granted time lot, that was in.
What is the offense?
Opposition NDPS, but not applicable to this petition.
That's a different story. Pay 1,000 rupees to the bar.
Yeah.
1,000? No further extension. 1,000 to the High Court bar. Which place?
One thing we submitted.
Which police station?
Jaipur town.
Give then local bar.
Yes.
1,000 rupees to be deposited with the bar association welfare fund of district bar association welfare fund of Koraput district bar association at Jaipur. Okay.
One thing to be submitted. In between charges submitted, charges may be taken into consideration.
Now, why should I tell that?
Obliged.
No further. This is the
Lordship.
application for extension. Yes.
Lordship, I am appearing in item 6.
Item 6.
On behalf of
I am appearing on behalf of opposite party number 2.
7.
6. Item number 6.
Lordship, item number 6, I am appearing for opposite party number 2. Lordship.
6.
Item. Lordship, am I audible, Lordship?
Yes.
I am appearing on behalf of opposite party number 2, Lordship. notice was issued on this.
Sorry, I didn't follow you.
I'm appearing on behalf of opposite party number 2.
Opposite party number 2.
Lordship, yes, sir.
Okay, so and so entered appearance for opposite party number 2 on behalf of the applicant. A request is made for adjournment. Is the matter? Yes.
Item 7.
May it please your lordship. Item 7, my lord. Initially, your lordship, the petitioner filed this application, challenged the order of learned magistrate, your lordship. Your
Yes,
lordship
yes.
called for a status. Your
1
lord,
minute. There is a status report I have called for.
For this item.
So let me.
Yes.
You appeared.
Bishop, I had filed a status report on 1/8/2025, stating that the the actual owners are in the possession of the cattle.
Owners.
Yes.
No, that was not the issue. Issue is how much they have to pay.
Pardon?
The owners
no,
have
my
taken.
lord, no, my lord. Your lordship called for a status whether the cow is, the cattle are with me or not. We are the custodian.
The cattle are with the Gosala, or it has been released. Released to the accused person. That is the case.
Can I?
Just-
The last point of that instruction.
That's Mr. Maharaja. That's the issue. That's the issue.
Yes. Apart from that, I have to place 3 points.
I am not going to hear. Just
Yes.
no.
Yes. Let your lordship see whether your lordship order has been complied or the cattle has been released in favor of the accused.
Should the over the page?
Yeah, according to you, it is released.
No. No, Miller.
Lordship, kindly see the.
Then it is
over the pages.
it is there with in the Gosala.
No, Your Lordship, actually with the actual owners. Lordship, kindly see the last
Actual
Who
point.
is the owners?
Mm.
Who is the owners?
No, I am
Actual
not going to
owner-
decide that. Sorry, Mr.
No, my lord.
I'm not going to.
My lord, who
Who is
is
the
the
owner?
owner?
Whether
Can
it
I
is
see the
only
last one?
if it is there with Gosala, the expenses has to be given to Gosala. That's the only issue.
My
Yes,
lord,
That's
this
the
is
only.
not the case, your lordship.
In
What?
the meantime, I
what
have taken all
I
the
am
previous
saying, my lord,
cases
clearly,
in the above noted case to the petitioner. Who is the petitioner here? Who is the petitioner here?
petitioner is the Gosala, my lord.
That is the.
No, then just see.
She kindly see the last point. Your
And
Lordship.
last point, which is double tick you have put
Lordship, the over the page last point.
over the page.
Yes. Lordship.
No, the double tick which you have put, they just see.
Yes.
In the meantime, I have taken all sincere steps to hand over the seized
Yes, sir.
cattle
Yes.
in the above noted case to the petitioner as per the order of the Honorable High Court of Orissa.
Yes. Lordship.
Further contacted, petitioner means Gosala here.
Yes. Lordship.
Further contacted all the Jimadars noted above to hand over the seized cattle given in the Jima
Yes.
to them. But they did not cooperate
Lordship.
in handing over the seized cattle. Further, I came to know that out of 142 numbers of cattle, 10 cattle
Died.
have already been died in the
Yes, sir.
meantime. I have also collected the postmortem copies of 10 so and so,
Yes. Lordship.
and submitted to the Honorable Court of JMFC, Udagiri. And as the Jimadar noted above failed to produce the cattle and which they had taken in Jima, as per the direction of SB so and so, case has been registered against so and so, so and so, so and so.
The last point would clarify the interposition.
This one, huh?
Yes. Lordship.
Sincere steps have been taken by engaging myself regularly to recover the seized cattle above noted case, but being unsuccessful. After completion of the investigation, so and so have been submitted against Jimadar accused persons, namely so and so, by showing them as an absconder in the case, and we subjudice before so and so, to compel their presence. Yes.
Yes. Lordship. The actual possession of the cattle are with the accused person still now, as per the report. Your Lordship.
No. They're absconding.
My lord.
They're
No,
absconding.
might
If
be-
they're absconding, how they have taken it?
Might be, Your Lordship, but the report shows.
But, my lord,
May
I am
I-
clarifying,
Preceding
my lord.
paragraph.
May
Please
I
hold on.
finish?
Please hold on.
May
My
I-
lord,
Preceding
state
paragraph
is
says it was
confusing
given
this
to-
matter. State is confusing this matter, my lord. What happened? I am submitting, your lordship. I will
Hey,
take 2
see,
minutes, my lord.
Mr. Sahu, if you are confused, that is your problem. I'm not confused.
I am not confused, my lord.
let
State
me
is
understand
confusing
it.
this matter.
Let me understand it. Please
May
hold
I
on.
pray, Your Lordship? May I pray, Your Lordship? The petitioner has nowhere stated that they are in possession of the actual.
Who is Jimadar?
Jimadar as in the accused person, sir.
No.
Yes, Your Lordship.
But the preceding paragraph says that it was given to the petitioner.
Lordship, may kindly appreciate. It would be sufficient if a report can be called for from this that court in session.
Now, I am not going to give indulge in an inquiry. You have to be very clear.
Your Lordship, I'll file an
See,
affidavit.
on the one hand, you are saying
Yes,
the
Your
accused
Lordship.
persons are absconding.
Yes,
In the
Your
same time, you are saying that it was handed over to them.
Yes,
In the
Your
preceding paragraph, it is said that it is given to the petitioner. What is the reality?
The steps are taken to hand over the cattle to the petitioner.
I'll just read it once again, the last paragraph. Since steps have been taken by engaging my staff regularly to recover the seized cattle,
Yes, Your Lordship.
above noted case, but being unsuccessful.
Yes, sir.
Siege is unsuccessful.
Yes, sir.
And the same time, preceding paragraph says 140 was there, 10 died.
10 have died.
10 died.
Yes, Your Lordship.
And in the this paragraph, it says that
Yes.
they are not able to seize them.
Yes.
Okay. After completion of investigation, G. Udagiri PS so charge sheet has been submitted against Jimadar
Yes.
accused persons,
Yes, sir.
namely so and so,
So and so.
showing them absconder in this case, and which is sub judice in the court of law. In this connection, obtain NBW against them, the Honorable so and so, to compel their presence in the court of law.
Yes, sir.
At present, the above Jimadars are actual possession of the
Yes,
cattle. That there we are saying,
Yes,
actual
yes.
possession of the cattle, as no any intimation received from the above Jimadar regarding the handed over of the cattle before Sri so and so.
Yes, sir. That is my instruction, that actual possession of the
But the
cattle.
preceding paragraph says that it was handed over.
The steps are taken. There are two set of.
Why don't you clarify it?
I'll clarify.
Why don't you
Lordship.
clarify?
Yeah, I'll
See,
clarify,
the
Lordship.
pursuant to the order of this court, dated, which was the date? 1 minute. Which was the date? Which was the date, madam?
Uh,
Order was passed?
May I?
It might be
May I submit my
22/7 or
lord?
18/7, Your Lordship.
20?
18/7 only, Your Lordship.
Okay,
18/7.
18/7.
Might be.
Pursuant to the order dated 18/7/2025, the IIC Udayagiri PS, GR Udayagiri PS has submitted a report dated 1/8/2025 in the last para, the last para so and so and so and so. It root, double tick root. Double tick root, there is nothing to get confused. It root, I will put it from
My
here
lord,
to
what
from
I
here
am
to-
facing, my lord.
from here, write down, huh? The reading of the aforementioned, reproduced part of the report leads to confusion as to whether the cattle are in possession of the petitioner Gosala or with the Jimadar oblique accused person. The IIC R. Udayagiri PS is directed to remain present through virtual mode on the next date of hearing. Let him come.
My
Tuesday.
lord, the four
Yes,
accused person are the volunteer
will
of our
come.
Gosala, my lord.
Okay,
If-
Tuesday.
Lordship,
My lord,
you
Your
should call for
Lordship,
a personal appearance of
please
that.
kindly
Let
allow
him
me. I
appear
am for
in
the
confused.
petitioner.
1 minute.
I am for
Let
the
him appear in.
Gosala. Without hearing my
Let him
side,
appear
how-
in
As a Lordship.
through which.
May I pray, Your Lordship? In the meanwhile, let the parties both are claiming that they are in actual possession.
No.
of
But
cattle.
then it is the IIC who is.
ISC will clarify. He'll
Let him come. Let him come.
Let them.
My
No,
lord,
no,
I am
no.
the
He is not
person of
clarified. Let him
Gosala. I
appear
am
in
the
person.
person.
Let me ask.
Your Lordship, allow me to speak, Your Lordship. At least allow me to speak, my lord. Please, Maharaj, Mr. Maharaj, I am not
Petition has been filed before the trial court while the order has not been complied by the IIC. Your Lordship, I kindly see this is the certificate that I have given.
Let him come. Let him
Yes.
come. Let him come.
Yes.
We'll see. Let him come. Tuesday.
My lord, I
Tuesday.
am
Tuesday.
Gosala. I am
Tuesday,
Gosala. and
Tuesday,
four accused-
Tuesday.
Four accused.
Hold your breath for
What happened, my
Tuesday.
lord? My
Hold your
lord, we
breath
are
till
taking
Tuesday.
care. Your Lordship, at least hear me for 10 seconds, my lord, without allowing
I
me,
have.
my lord, Your Lordship.
I need to hear only the IO. Let me see that.
Yes.
Yes.
What is the matter, Your Lordship?
I'll
What is
hear
the
you.
matter
I'll
about?
hold your breath, Mr. Sahu. Hold your breath till Tuesday. Heaven is not going to fall within Tuesday. Hold your
What
breath till
happened in this
Tuesday.
case, my lord?
Let him appear in
Your
person. We'll
Lordship,
see.
allow me for 30 seconds.
Lordship,
Your
a fixed
Lordship,
timing.
allow me for 30 seconds today only, my
30
lord.
seconds to repeat one, whatever you have already said.
No, my lord. What happened in this case?
Okay, 30
The
seconds.
police handed
Okay, 30
over.
seconds.
the
30
police
seconds by
handed
what?
over- The police handed over 142 number of cattle to our volunteer. The 4 accused person, our volunteer of our Gosala. They received the Jimanama and handed over to the Gosala. Who will receive the Jimanama, my lord?
That
Any
may be the
person-
that may be the reason the confusion. He says what he
Now-
is trying to say is one
Now,
minute.
what is the case?
One
my
minute,
lord?
hold on. What he says is
Yes, Lordship.
the Jimadar,
Yes,
the
Lordship.
4 accused persons
Yes,
are part of the Gosala only. So Jimadars are the 4 accused persons.
Then
Out of them.
there should not.
So they have taken it and given it to Gosala. That's what he says. Let us understand. Let us understand from the IU.
Absolutely, sir. Let him come on Tuesday.
The overlapping.
Clarify.
Why it is overlapping is who is Jimadar? Jimadar is 4 out of them only. That's
Yes,
what he
my lord.
says. So therefore there is a confusion.
Then why have they filed the CRLMC recall and everything?
Let us see, understand. That we will go to the next step. Let us understand who, the
State
cattle
of-
are with whom.
If it is with them only, there is no point.
You are right there. I
CRLMC
understand it.
alone.
But let us understand.
My
it.
lord, my lord,
Yes,
Let us
State
understand.
Council
No,
is-
he is only interested that the expenses has to be
Yes,
given by whom.
Yes.
They are taking care. The Gosala is taking care of the cattle. Who will bear the expenses?
Yes.
आगे पता आपको ना
Either accused, those who are absconding, or the government.
ସେଇଟା ଠିକ ଯାହା ହଉଛି ହଉ ମତେ ଖାଲି ଦରକାର ଗାଈ କୋଉଠି ଗଲେ ବର୍ତ୍ତମାନ ଗାଈ
Tuesday.
କୁଆଡେ ଅଛି ମତେ ଏତିକି ଦରକାର
Tuesday answer.
My lord, I-
there is nothing to forthcoming.
Why are you absconding then?
No, we are not the accused person.
Who are you?
Yes, they are not the accused person, my lord.
You are the original owner. Your cows were stolen.
The cow was taken by the IAC.
No. You are the original owner of the. Your cows were stolen by a couple of people, and which was apprehended in that effort.
Right.
That's what, right? So now it is
My
between
lord,
the original owner and the Gosala.
Blunt, false statement, my lord.
But you
They
know
are
that
the
you know that
traffickers.
it is not with you.
No.
They are the traffickers. They transported the cattle for the
Shady,
purpose of
shady.
slaughter.
ମୁଁ ସେଇଟା ଦେଖିବାକୁ ଚାହୁଁଥିଲି ଆପଣଙ୍କୁ ଟ୍ରାଏଲ କୁ ଅବଜେକ୍ଟ କରିଛନ୍ତି ପୁରା ଏବଂ ଆପ୍ରୋଚ କରିଛନ୍ତି
Why the IAC doesn't know where the cattle have gone?
Lordship, kindly post it to Tuesday.
Let him come at a pace. Let him come at a pace. I'll ask.
The petitioners are the trafficker of cattle. Police seized the cattle from them and handed over to the volunteer of Gosala. Thereafter, we are taking care of the everything without challenging the veracity entire order. They challenge the one condition, white CRLMC number 4435.
I know that.
By
I know
force-
that, Mr. Sao. I know that is the reason I have given indulgence. Otherwise, I would not have given. Let me understand. Let us locate the cows first.
Mr. Maharaja falsely stated, my lord. That's why I filed recall application.
I'm sorry, brother. I'm not
Let-
here to
Next.
listen your submission.
Next.
I am submitting false.
Next slide.
My lord, your lordship may kindly note it.
No.
I have submitted false. Your lordship may
Yes, my lord. Kindly note it,
Tuesday
your
answer.
lordship.
On Tuesday.
7th January 2025.
I am habituated of listening false things. Don't worry. Next item.
The live streaming, my lord,
Hold your
27
bean.
minutes 10 seconds.
Okay. Next. Yes. IAC. Let the IAC come.
Yes. Sir.
There is some confusion here.
Yes.
Tuesday.
Next Tuesday.
38 ରେ କଣ କୋଉ ବର୍ଷର ଏଟା 94 matters. Tuesday, huh? Tuesday, and you take it. Huh?
It's a vigilant
Tuesday.
matter. Can it be taken on Thursday?
Which one?
Same 38.
Yeah, Mr. Maharaja, he is appearing for that
Yes.
matter.
I am ready. For today also I am ready. Then we complete it to 38. Yes.
No, I'm sorry. I have to prepare.
He is not prepared. Let him come.
After
Tuesday.
vacation,
It has not been separated.
reopening day. Reopening.
Are you traveling next week?
I am not traveling. I am here.
Let us try and
Yes.
Tuesday it happens.
Yes.
Doesn't happen. No problem. Let him prepare.
Thursday.
If you say vacation, then he'll forget the brief.
Thursday, ma'am.
He's in the mood of preparing, let him prepare.
Thursday,
If it doesn't happen, then it's all right. Thursday. The best thing is without reading, you are saying chote case. Thursday, huh? Thursday. Okay.
Item 8.
Item 8, you are having some time. 12.
8, no report. Okay. Tuesday. Thursday. पास ओवर कर दो ठीक है ठीक है नो प्रॉब्लम
Item 9.
9 पे कौन है भाई एलाइव लो भैया
Item 10.
9 see he's alive get ready I'll hear huh? What is the offense
NDPS Act, 2 years conviction.
2 years करने I'll hear it no you have to give a date because other hearings are there this is a 2007 matter na I'll hear it yes I'll give a date yes
Item 10.
10
Then
in the alive yes
Item 11.
pass over yes 12
12.
Well, actually, the address is from Punjab. The accused is from Punjab, so it is very difficult to trace that person.
Dara Singh
Yes. His address is, my lordship.
what was his age
He is 61, my lordship. In 2007.
61 in 2007
Yes.
just see now he must be in
Yes. 88.
80s but I just give a longer date after vacation try
Yes.
right yes
But the accused cannot be stressed, my lordship, because from Punjab it is very
Punjab is part of India it seems
Yes, my lordship, but
you can search it try and you send it to the local police from
yes,
here
I have already
and
sent my lordship to the
local police has to inquire from the Punjab
Yes.
police and get a report so therefore I'm giving a longer date okay
Item 13.
13, my lordship, alive, my lordship. The
Sorry,
report
alive.
is the alive.
okay you have the report
Yes, ma'am.
okay 14
14, my
14 13 in any case it will be taken up later yes 14
14 not received, my lordship. 14, 15
14?
not received, my lordship.
not no report okay pass over or
My
Tuesday next Thursday
Yes, ma'am.
next Thursday yes 15
15 also not received.
Thursday next
Yes,
Thursday
16, my lordship.
no only for report don't worry
Okay.
after report it will go to after vacation I'm waiting for the report don't worry
16.
60, my lordship, report received.
Alive.
Yes.
16 later 17
17.
17, my lordship, not received.
not received Thursday 18
Not received.
Thursday
Yes.
okay 19
19.
19, my lordship.
alive
Yes, one died and other two are
one
alive.
died देखो the appellant number appellant Tarat Bishoy died देखिए देखो and the rest of the yes
20.
20 alive.
20 alive has been expired on
No, my lordship.
20 दिन alive
Yes, ma'am.
okay 21
21 not received, my lordship.
not
Not received.
received 22
Alive.
23 20 22 you're talking about sir when do you want after vacation immediately get ready what is the offense get ready with some small note so that we can
Actually, my intention.
immediately after vacation
Immediately.
okay and 23 time Thursday next Thursday okay 24 one died how many appellants are there oh okay give the report report has come take the report one died and yes
25.
25 Thursday
My lord, sir, in 25,
25,000.
And then 25, it's a vigilance appeal. Though 2 orders have been passed directing the state council to ascertain the whereabouts. If they are taking that initiative, I don't.
Are
have
you
any problem.
taking? Okay, vigilance appeal record diyo. Which SP?
25.
Which SP? Which area?
Yeah.
Hmm?
Yes, yeah.
I think he's for that.
Career means that must be Nuapada. Vigilance, vigilance would be Nuapada to submit a report.
That's
25.
after vacation, madam.
After vacation. After vacation. Nuapada or Bhawanipatna?
Churi Baripara town, Bhawanipatna district, Kalahandi.
Bhawanipatna county.
This is his address, madam. So far as the case is concerned, it is of
So Nuapada and Bhawanipatna dono kar do. Nuapada and Bhawanipatna.
Jaipur, madam.
Let
Special
it
Judge
come.
Vigilance, Jaipur.
57 in there, man.
74, I was calculating the age. At present, he must be 74 if he is alive. If he is alive, then he will be 74. 3 weeks time and 3 weeks time.
After this pandemic, you never know.
Yes.
Age has no meaning.
Yes.
Many of them in 50s and 40s also die. Yes.
That's 3 weeks put
Ah.
after 3 weeks.
After vacation. After vacation. Yes.
Great.
26.
1.4 are alive.
The day 1 to 4 alive. Yes.
27.
27. Thursday. Okay. 28. Alive. Okay, alive. Report there. 29. 29 to 30. Thursday. Okay, pass over. Okay. Pass over. 34.
34 will also no one more opportunity.
Okay, 34 one. No report. Thursday.
35 also same.
Huh?
Same will also.
No report Thursday.
35,
That is-
I am appearing on VC, my lords.
Yes.
State to obtain instruction in this
Yes.
matter.
Yes. Next Thursday. 36. But let us see the report.
report yet received also.
Thursday. Let them get after vacation it will go. Don't worry. Yes. 37.
7 sole appellant will expired also. Report.
Sole appellant. I just see. Sole appellant. Banamani Tripathi died. Died. Awaited. Hearing. 38 urgent. 39.
39 ready for hearing.
Ready? Prepare a note. Okay. 1 minute. I'll just run through. 40. 40 minute lo gayi.
40 also ready. Ready for hearing also.
40 minute.
41.
41 also ready for hearing also.
Huh?
Ready for hearing also.
Okay.
High pay 2025.
Kitne, how many matters are ready for hearing? 50?
38 onwards, all the matters hearing matter.
One bail, huh? Bail, what is that? Which item?
54, last item.
54. You got the report 54.
54 my line.
Yes. 54, have you got some? I've asked for some report.
Answer the order of effect 9/9/2025, last order.
Yes.
They are in direction. Talk to the harmony day.
Yes, yes, sir. I know.
The 407 there, that has been infected in your judgment order. In Miller, all of these, you have that choice, the 3 years and 1 month. And in the meantime, Miller, 7 months already. More than 4 years, 8 months. Running page Miller in judgment, internal page. I have also submitted no incident.
Yes.
Yes, sir. This is the instruction.
Total custody period is custody period how much? One 689 days means how much? 1689 days. Let's see.
4 years, 8 months.
1689. Just check it out.
Please custody all 3 CA can use that equals.
No, I am telling you the number of days. Actual sentence period is 1689 days. Divide by how many years and how many, just check it up. How many months?
4 years, 8 months. Counting.
Yeah?
4 years, 8.
Are you sure? 4 years.
4 years, 7 to 8 months approximately.
7 months, 21 days. And that has been after.
What is his address?
Address, you know.
Gopalganj, Bihar.
Bihar, madam.
Gopalganj, Bihar.
No, antecedent.
No antecedent, but is
Outside of state.
bound to clear.
Yeah, conviction that the has for potato appeal hearing no validity.
Appeal is of 2024.
24.
Right.
It can differ.
I'll give him for 3 months first. Let us see his contact.
Yes.
Thereafter we'll see.
Yeah.
Right. Whether he comes or not.
Yes.
The matter was heard on the 54. Right? Matter was heard on 9/9/2025. The following order was passed. Pursuant to the aforementioned order, the Superintendent of District Jail, Balangir, has submitted a report dated 15/9/2025, which reads as under. The superintendent has also submitted a custody certificate. As per the custody certificate, the appellant has already undergone about 1689 days custody. Regarding head to the aforementioned report submitted by the jail authority, Mr. Kondal, Learned Counsel for the appellant submits that the petitioner is entitled to bail pending the appeal. However, the counsel for the state has a reservation on this only because of the reason that the petitioner is an outsider. He further submits, the counsel for the state submits that there is all likelihood that the appellant may abscond once he is admitted to bail. Taking into consideration the submission made by the parties at the bar, for the time being, the petitioner is granted 3 months interim bail. Huh? 3 months interim bail.
3 months only.
interim bail. From the date of the release, with the appropriate condition to be imposed by the legend trial court. Immediately after expiry of the interim bail period, the petitioner shall surrender before the jail authority. While charging the petitioner on bail, the petitioner, the appellant shall furnish a local surety, and also furnish his present address and permanent address as well. On verification of the said address, the trial court shall release him. Okay. This is the matter after the petitioner, the appellant surrenders before the court, and report be furnished before this court. Yes.
January की date था surrender certificate में January की वो date. That is special assigned only money. So January की वो date.
That's what I'm saying. Once you surrender, it will become.
It's
Yes.
I leave no surrender certificate.
Surrender. Yes.
Forty-one. 42.
43.
43. 42.
Pass over, huh?
43.
Yes, Mr. Mishra.
43 is the one, Your Worship, I wanted to know whether detailed examination under section 313.
But then, Mr. Who was detailed examination under?
313, Your Worship.
That will.
In the intermediate
Pass over. Yes, 44.
That's for item 42 main contention, sir.
44, yes, Mr. Mishra.
I am there.
What is the offense?
My lord, initially charged for 302, but conviction under 304 part 2 and sentenced to 3 years RI. Along with other offences, 342, the bag, the bag, the background.
He must be trying to assist you.
Yes, madam.
Yeah.
But this very movement here is disturbing. But here the facts are like this. Not a small boy, a baby, he was sacrificed. So the uncle of that boy, he suspected that this deceased in the present case, that is Himanchal, that he is the main person who sacrificed it at the behest of the eyewitnesses here. So there was a scuffle. So villagers surrounded and they assaulted that Tantrik. Yes. And he succumbed to the injuries in the hospital. And for the committing murder of that baby, the deceased died, the person who hired that Tantrik, they were convicted and they were sentenced to death. But subsequently they got released in the Supreme Court. High Court confirmed, however, Supreme Court acquitted them. This is the offshoot of that trial. During a scuffle between 2,000 persons clear out the area.
2,000 people.
Yes, ma'am. That is the evidence.
How many accused?
Well, 5 accused.
Still stands elected against the total 1 and 2.
5 accused persons, 1 and 2 are dead. Those 2 are the uncles of that baby. Maternal uncles.
1 and 2 have died.
Yes, ma'am.
1 died, huh?
1 and 2.
Only 3, 4, 5.
And 3, 4, 5, they are members of the public. These first 1, 2, they are the uncles of that sacrificed baby. So when the tension mounted and there was an outraging of that area, so the public cleared out and public assaulted.
How the 3 people were picked out? out of too many.
But because they were the friends of this appellant number 1 and 2, and these witnesses who got acquitted in that sessions case, they implicated these 3 persons amongst somewhere they say at times they are 40-50 persons inside the area, and outside the area there are almost 2,000.
Okay.
And
Is there anything attributed to these 3 people?
general assault, my lord, that everybody assaulted the
No, anything recovered from these people?
no
Weapon?
no weapon, only slaps and kicks. And somebody says that the deceased head was dashed against the wall, so he died. And one witness says that it struck on a box, wooden box, resulting in injuries to which he succumbed afterwards in the hospital. No offense of weapon of offense is there. And it is also in the evidence that they were imposed with death penalty. They came, those
They were
witnesses.
acquitted in the trial court, High Court.
No, High Court confirmed. In the Supreme Court, they got acquitted.
All of them.
Yes. 44.
Do you have that judgment with you?
Yes, madam, I have the judgment.
No. Supreme Court judgment.
No, that I don't have.
Yes.
That
Is there anything said regarding this case?
No, that instruction I don't have because in
Let
fact,
us see if any findings are there which will help you or which will not
yes,
help you.
yes, madam. In fact,
Uh,
I couldn't find that number. Sessions trial number is there, but appeal number here and SLP number in the Supreme Court I couldn't get. Now I will take assistance of that.
Please see, because if anything is
Any
any order is
observation,
passed,
any observation.
some observation is there, then
Yes,
we
that
may.
may help.
Then I just put it immediately after vacation.
Yes.
Immediately put it.
Can I get a date, my lord?
Not detail. I'll just come.
14.
I'll just at 12 o'clock I'll start hearing. 12 o'clock till 12 o'clock. And that matter is there.
What 3-4 matters there? Can be anything.
You want 2 o'clock, then I'll start your matter at 2 o'clock. Because madam is there, I'll start at 2 o'clock.
Yes, sir.
At 2 o'clock, you be free with all other matters. Let him come at 2 o'clock. Let him be free. I'll hear madam. Huh? Okay.
My lordship, some instruction have received right now. I'm just saying.
Give it.
There is a lottery father, my account number 31. By appeal, the lottery directed to government, council to obtain instruction about like whether he is alive or I am appealing for the appeal. He is alive.
31?
So it may be
31, 31 it's all right, huh? 31, 31 level counts for the appellant submit that the appellant is alive and he is ready to argue the matter on merits, release the matter on subject. Okay? Date will be fixed immediately after vacation. Immediately after vacation, he'll fix a date and he'll come to the.
so क्या matter is not the one.
Definitely he'll give you the date. Sure. Yes. 30?
Right.
49? Yes, madam. Written note, okay. In which matter? That's okay. Thank you. Yes. 39? Yes, madam.
This is a NDPS case matter, my lord.
Yes.
Four appellants here. The four appellants filed appeal against the order of learned additional sessions judge Kotak,
Yes.
wherein they are convicted under section 15 of the NDPS Act, and you are sentenced to undergo RI for 1 year, RI for 10 years, and rupees 1 lakh fine. So out of 4, my lord, appellant number 2 and 3 already dead. Your lordship will hear from me.
2 and 4.
Appellant number 1 and
2 and 4 died.
Manas Ranjan Sahu, Audi Bandhu Rao, who had been expired, only
Yeah,
remaining
but my
appellant 1 and 3 is
Oh,
concerned.
Balu, no, Balu is not here. Driver Subhash Chandra Lal, Subhash Lal.
Yes.
As per your lordship, I have prepared a small note.
Yes. Give me the note. Get it.
Which citation to judgments are there. Study.
Okay.
And written note.
Hello.
Very good.
Yes, I have
Sir.
got no time, so my
That's all.
handwritten.
No problem. No.
The prosecution story in brief is that on dated Dewey oblique undated 21/22/94 night PW8 Sharat Chandra Janamani, Circle Inspector of Athagada, while was performing anti-dopiety patrolling along with PW6 of Badamba PS and other staff of Badamba PS, Tigriya PS, and they are in at Patak Narsimpur Road at Noapatna. On that night, at about 2 a.m., they detained a tractor which came from Narsinghpur side. At that time also, one mini truck bearing registration number OSF 6485 came from Athagada side, and that also was detained by police for checking. In the said mini truck, these 4 appellants were sitting in the cabin, including the driver Subhash Pal. On suspicion, the PW8 Mr. Janamani climbed to the truck and found 6 gunny bags containing poppy straw. The PW8 seized the truck and 6 bags containing poppy straw. The PW8 drew a FIR on the spot and sent the same to Tigriya police station for registration. After completion of investigation, charge sheet was filed against the present 4 appellants under section 15 of NDPS Act. The plea of the appellants were that police detained them and asked to load and carry the 6 gunny bags, to which they refused.
You come to second page, last paragraph. Police seized 6 gunny bags on
Yes, ma'am.
22/2/1994 containing the poppy straw,
Poppy straw.
but the same were produced on 30th
Four.
April 1994. That is means after 6 days. 7 days.
CJM Cuttack.
And
And
Cuttack.
the same was sent to chemical examiner.
On
It was also too late.
2/5/1994 with an inordinate delay
Inordinate delay.
creates a suspicion.
Get suspicious.
And the prosecution case is not
not
free from
free from
suspicion and
suspicion.
they
Yeah.
not
It
established.
has not been established beyond reasonable doubt.
So on, so on.
The impugned judgment is to be set aside because
Nobody
of they have not followed the due procedure of law while recovering the 6 gunny bags. And also sample collection was not
And no evidence was laid by the prosecution to
with regard to that is a possession. You know,
the effect that the bag containing poppy straw was recovered from the possession of the appellants.
from the possession of the appellant. And
These are the two grounds you have taken.
crimes only.
Only these two grounds. One is you say that it was produced before CJM after 7-8 days,
That not.
and which
And
there is no
also-
explanation.
Huh.
Second is possession
Possession
is not true.
Minor.
Let us see these 1 point and 2 point. Let us see the evidence. And you are relying upon two judgments, that is Simranjit Singh versus State of Punjab,
And also
and the other one is Avtar Singh versus State of Punjab. These are the
Right.
two judgments you are relying upon. Okay, let us see the evidence now.
evidence.
Come to evidence.
They are
PW8.
PW8 is the main person.
Yes, main witness.
Mainland.
Come there.
On 22/94, I was circle inspector of Athagada. At that night, my 21/2/94, 22/21 later, myself DD Naik, Bodama case, along with PW5 and PW7, including some OSAP, were performing anti-dacoity patrol duty on Narsimpur Athagada Road, checking the vehicles at Noapatna, Durga Bazaar. At about
Come to para 2.
past
Hmm.
2 hour query,
Hmm.
the accused persons told that they were
Carrying
the
husk.
On
On suspicion, I climbed
I climbed to
to the Dala of the carrier of the mini truck, and after giving personal
personal
something of the hours of the accused person, I found 6 gunny bags in the carrier of the mini truck and
Mini truck?
while filled with poppy straw. At that time, the driver and helper of the trucker were also present.
That is another
Accused
record,
persons were
not
carrying-
this minute draw. As the accused persons were carrying the poppy straw, without any authority, I seized all the 6 bags along with the vehicle and prepared a seizure list in presence of the witnesses, which is Exhibit 1 and 100. Is my signature on this seizure list along with my endorsement. I collected samples from each of the gunny bags and prepared a simple six sample packets. All the sample packets and the residue kept inside the gunny bags were sealed by me.
Who is PW1?
PW1 is the PW1. Driver of the tractor.
Who is DD9?
DD Naik.
He says that after sealing it, he gave it to the DD9 and Pradeep Behra, PW1.
PW1 is the driver. He has not supported the prosecution case.
Who?
PW1,
Driver of
a driver of tractor.
the tracker.
4 are independent and other of 5 to 8 are also police officials.
Independent witnesses have not supported.
No, my lord, nobody. I do not know any of the accused. I am a driver, single.
Abhimanyu was not examined. I found 31 kgs.
Poppy straw.
Abhimanyu,
6 bags.
4 years.
Yes.
Actually, paper पढ़ी होने नहीं दे रहे तो देखा जाऊंगे अभी मान लो इनका PW4 से कौन सी it is page 41 I am having a rice cooler at village Noapatana in the morning police babu of Atlora requested me for my weighing instruments to which I denied तापर से कही थी cross examination है it is not
from the date of the seizure up till it was sent to the chemical examination test, the samples and the seized articles remained with whom?
But the OIC degree alone, Malkhana under the OIC degree alone.
Where is that?
That is an impugned judgment. Your
No, you have to come to the evidence.
The copy of the PW evidence of the PW 8 yours.
PW8, where does he say?
That's it.
all the work we have done से सब जो sample collection है PW8 ର paragraph 3 ରେ ଲେଖା ହେଇଛି I collected samples what I am challenging my lord the collection of samples was not in accordance with the law laid down by the Supreme Court that is the my
Your Lordship, that is in
citation
running page of the 50 PW 8 Your Lordship, paragraph 4. I sent the same to degree of PS Lordship for its registration.
on
I sent in the materials. Contraband
Para 4.
Lordship.
Immediately took up the investigation,
And
written
during the
so
affair,
and my signature, I sent the same to the person
exhibit 3
for registration and the formal. I am talking about something else.
Lordship, I am on which custody of the contraband article, Lordship.
The problem is you people don't read. That's the entire pressure is on me only.
Lordship.
No assistance. These are, see, 10 years sentence and
Yes.
this is a NDPS case. You have to come with the answer, either you answer or
Kindly.
PW8 is the witness who is the IO.
Yes, Your
we
Lordship.
die
Then where he has explained the delay.
no hair my lord delay is not explained in no hair but only so inordinate delay in depositing the same before the court below but the procedure which is to be adopted by the prosecution they have not followed that is also in our statute also I am reading the judgment. Section 52A minor, subgroup 2, where any narcotic drugs, psychotropic substances, controlled substances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered for section 53, the officer referred to in subsection 1 shall prepare an inventory of such narcotic drugs, psychotropic substances, controlled substances or conveyances containing such details.
Madam, first you read the evidence of PW8.
Madam,
Thereafter, you tell me how
What is
this the violation of the provisions. First, let us understand the fact
yes, yes.
from the evidence. Because in the written note, you have only given the prosecution story and you have taken only 2 points. The first point you substantiate from the evidence. Then show me the law. The first point you have said that the siege articles were produced before the CJM after 8 days. Where is that? Where from I'll get it? From PW8, where from I'll get that it was produced on 30th of, where from you got that date? 30th April,
Fine, that is in page 52, your lordship.
52.
52.
Yes. Where is that?
Page 52.
Ah.
I produced the
Which para?
in the front,
Huh?
first line. 52 page, first line.
Okay, yes. I produced the bag before this so and so on 30th. So this is the date. Okay. Okay.
Samples were also collected from each of the bags in the court of CJM.
And it was the sample was kept and it was sent to the chemical examination report on 2/5/1994.
My lord.
Okay. Okay, the two dates are there. Okay.
On the same day, I thought that
Yes.
I directed OIC to PS to.
In that regard, which is the judgment you are reading? Show me.
Hello?
So give me the judgment. Where is the judgment? Which paragraph, madam?
Amen.
Simranjit Singh, Punjab. Which paragraph?
Oh, okay. Just a minute.
NDPS. right?
If you share it, the shares of the prosecution will checkable. The appellate permitters will act out drawing samples from all the packets at the time of seizure is not in conformity with the dictum laid down in Union of India versus Mohanlal and another. That is, which creates serious doubt about the prosecution case that the substance recovered was a contraband. As the prosecution case is not free from suspicion and the same has not been established beyond a reasonable doubt, the impugned judgment besides the appellant is set aside and conviction and sentence quashed, appeal allowed in that case. So, my lord, your lordship can see Simaranjit case, sir. Paragraph 8. That is procedural. May I read, my lord?
1 minute.
Para 8. And they have quoted the decision.
1 minute, madam. Yes. Which paragraph you are reading?
Simaranjit case, sir.
Learned counsel appearing for the appellant relied upon the decision of Mohanlal, and the prosecution vitiated as the work of drawing of the sample done by PW7 without taking recourse to subsection 2 of section 52 capital A of the NDPS Act, and it pointed out that the examination chief of so and so, or the which shows that the samples were drawn immediately after the seizure. We have perused the evidence of PW7 operations, which has stated that from the 8 bags of poppy husk, the 2 samples of 250 grams were drawn and converted to 16 parcels, and this has been done immediately after the seizure. In paragraph 15 of the decisions of Mohanlal, it says that it is manifest also when seizure of the contraband, the same has to be forwarded either to the officer in charge of nearest police station or to the officer important section 53. Section 53. Section 53. We shall prepare inventory and so on, so on, so. Section 3 of so on, requires that magistrate shall, as soon as may be allowed to the application, implies that no sooner the seizure is effected and the contraband forwarded to the officer in charge for the police station, and other officer power, the officer's concern is duty is bound to approach the magistrate for the purpose of mentioning or including grant of permission to draw the representative sample. You say that Mohanlal's para 16 is not complied.
My
Yes.
drawing
And
the
this one was
and also
prepared by the
photograph.
magistrate.
Nothing has done in
It's drawing of the sample of the seizure which are more often than not takes place.
question of drawing samples at the time of seizure, which more often than not takes place in the absence of the magistrate, does not in the above scheme of this thing. This is so especially when, according to section 52A4 of the Act, samples drawn and certified by the magistrate in compliance with subsection 2 and 3 of section 52A constitute primary evidence for the purpose of the trial. To find it so that there is no provision in the Act That mandates taking of samples at the time of.
Yes. Yes, this is regarding the first contention. First contention.
Fine.
The delay is not extended. And next
Then
point
open
is,
my lord.
your next point is, no evidence was laid by the prosecution to the effect that the bags containing poppy straw was recovered from the possession of the appellant.
Position.
How do you say that?
And like no here, it is written that they were sitting in the truck, but out of the 4 appellants, none of the, no exemption of that, prosecution has not examined on that point. From whose possession that contraband was recovered? No discussion also. So the 4 persons who were arrested, only because they are sitting in the truck, will it be suffice to say them accused? A judgment କହିଲା କି possession of narcotics through custody or control over goods must be proved.
Only thing is para 2, PW 8 says, on our query, the accused persons told that they were carrying the husk. On suspicion, we claimed and recovered. That's what they say.
I'm reading from that part.
After giving procedural or personal search.
Para 6 of that.
If there is a personal search, whether 50 is not also complied. 50 is also not complied.
But that is discussed in para 5 of the judgment. Section 15
50
provides.
is also not complied.
15 provides punishment if any person is in contravention to any provision of the act or any rule or order made or condition of a license granted thereon, produces, possession, transports, imports, exports, all these things. For purchases, issues, I mean, issues into nothing to warehouse copy, section 8. Enacts a prohibition against production, manufacture, possession, sale, purchase, exports, transportation. 5. The para 6 they have discussed properly. And may I read para 6?
Who is PW3?
Is a Gondadhara Naidu.
I know, I'm not asking the name.
Watchman.
We don't see.
Independent witness. In the cross examination, para 3, just read. Para 3.
Para 3 cross examination କହିଲେ କି? On 22 night, when I came out of her office, I found 5 to 6 bags were kept in the roadside, and police was there. Thereafter, I saw a mini truck which came from our side, police detained the said mini truck. The said mini truck was empty. Police Babu asked the mini truck driver to carry some those 6 bags to police station, which he denied. Thereafter, I went to NDPS. The allegation made against the prosecution by the police Babu ତାଙ୍କୁ କହିଲେ ନବା ପାଇଁ କି ଏମାନେ ନନେଲେ ତାଙ୍କ ନାଁରେ କେସ୍ କାଢିଲେ। And also the 6 money bags are found in the road, not in truck.
Chemical examination has taken place? Madam, chemical examination has taken place. Exhibit 10. Take out exhibit 10. Where is exhibit 10? Where is exhibit 10? Is exhibit 10? 1 minute. Okay, parcel containing one paper pocket and cloth with cloth which receives the relationship contain 6 numbers of set used from is found into samples and plant material to the copies from figure. This exhibit 10 was brought on record through whom? Yes, exhibit 10 through whom? Exhibit. Yes, exhibit 10. Submitted report, why do exhibit 10? Yes, madam, anything else? I read it. I read it. What do you want to say? Tell me. Anything else? This judgment and the another judgment you are relying upon this judgment, Avtar Singh. Avtar Singh for what?
Possession.
Possession.
Minor.
Which paragraph?
Paragraph 6 minor.
Please read it.
Okay.
Possession.
Possession 6. Possession is
It's
the
the core in interest of
instances are subjected to the punishment under section 50 if the accused are found to be in possession of copyright which is in narcotics within the meaning of clause substance of section 2. It is for them to account for such possession satisfactorily. If not, the
Presumption under section 54 will operate, whether the must be conscious breach. Whether he is proof of
from this decision of this court in Sankar 1973 SCC arising under the Opium Act. The learned trial judge charged the accused of having conscious possession of copy horse. Assuming that copy horse comes within the expression copy store. The question, however, remains whether the prosecution satisfactorily proved the fact that the success accused were in possession of copy horse. Accepting the evidence of PWO, the third constable, it is seen that appellant number 3, accused number 4, was driving the vehicle loaded with the bags of coffee horses. Appellants 1 and 2 accused number 1 and 2 were sitting on the bags placed in the truck. As soon as the vehicle was stopped by SI, one person sitting in the cabin by the side of the driver and another person sitting in the back of the truck here. No evidence, no investigation has been directed in ascertain to the role played by each of the accused and the nexus between the accused and the offending goods. The word position no doubt has different sets of meaning and it is quite relative on its connection.
Show me 313.
Position
Okay, 313, I got it. 313 of this, any one of them.
discussion करते हैं सेक्शन the object of exam is not the section 3
Madam, 313, show me.
it is well known to offer an opportunity to the accused to explain the circumstances appearing in the evidence against him. It is unfortunate that no question was asked about the possession of goods. Having regard to the charge of which the assailants were accused, the failure to elicit their answer on such a crucial aspect as possession is quite significant in this state of things. It is not proper to raise the presumption under section 114 of the Evidence Act, nor is it said to conclude that the prosecution established beyond reasonable doubt that the apparent were in possession of popular speech were being carried by the VP. The High Court resorted to the presumption of the section 35 which related to culpable state of mind.
Yes, I got it. Yes, what do you say, Mr. Mohan?
So far delay part is concerned,
Huh.
the London Trial Court is in the judgment in paragraph your lordship, page 16 of the paper books, your lordship, paragraph 12 is
Yes.
elaborately described
Hmm.
how the delays occurred in addition to exhibit 7.
Hmm.
The PW 8 exhibit, your lordship, kindly place the page 16, paragraph 12 also.
Which part?
Lordship, finally, the 6 gunny bags that the mid portion of the paragraph 12, your lordship.
Hmm.
Finally, the 6 gunny bags were produced before me, before CGM on 13/4. The CGM collected samples from each of the gunny bags and sent it to the commission with the forwarding report exhibit 8. The said sample packets were carried by the OIC Tigria on the direction of the Bureau 8 to the commission examiner to obtain a report of acknowledgement by the examiner. In the present case, the evidence before that 2 lines above, your lordship, that in paragraph from the 12 of the beginning, your lordship. Therefore, lordship, on 6/4/94, it's paragraph of the 12D, with the prayer of the executive to send them for chemical examination. As per the order of this court, he again produced those samples.
All are facts.
Lordship,
Where is the explanation?
Lordship, thereafter, lordship, exhibit 7 is given by the kind glance, the exhibit
These
7.
are facts only, everybody knows. But why it was produced on 30th?
The bill was kept in the ASA Badamba in the.
Why? It should have been, that is 52 capital A subclause 2. It has to be produced immediately. Where is the explanation?
Explanation as your speed rate is given in also.
Where is? No explanation. Show me. A single sentence.
Yes.
Yes. The last line, last two lines of that paragraph which you are reading. It says that since it was kept in OIC's custody, then it can be produced at any time. That's what the reasoning is. The reasoning, just see,
Proceed.
page 17, last three lines. The act itself has reposed confidence on OIC of the police station for keeping the seized articles in safe custody. As per the above discussion, there is no doubt that the seized gunny bags and the samples were kept in the police malkhana under the custody of OIC, and which were found in the same condition while produced before the CJM and this court. So the delay in producing the gunny bag before the court is of no help to the defense. That's what there is no explanation given why the delay has caused. Next, possession, insofar as these people were sitting in the truck
That's it.
and it was seized from the truck. Okay. And how these people, those who are sitting, four of them are sitting in the backside and one driver was there. It is from the conscious position. What is the evidence you have? Except asking them, are you carrying it? They said, yes, we are carrying it. Except that, what else is there? Means on their statement, you are implicating them.
The owner of the truck, PW2, has clearly stated that the.
What? Nothing is clearly stated. I read it. If you have read it, read it.
Subhas is the driver and Bhavat is the helper of the vehicle and two other persons.
He was in some other vehicle, not in the vehicle which was seized. Why don't you understand that?
They were placing the statement of the.
Yes, I read it. PW2.
PW2.
Yes.
And I was the owner of the mini truck, register number so and so. During that period, the accused, Paul, lordship, that
At that point,
Subhas Pal.
my truck, at that time, my truck was stationed in Nuapada. Means he was in the other truck. He's the owner of other truck, not the truck where it was seized.
This truck, ORF, OSF 6485.
But what is he saying?
I was the owner of the mini truck, during number so and so.
Then
I'm the owner of that vehicle.
Then possession is proved.
No, here is, I'm not sure, I'm saying.
Conscious position. I'm talking about conscious position.
And while the present four accused appellants are inside the mini truck and the contraband article was in the Dala lordship,
Then how we relate it to them? Just read the judgment which he is citing and read 313. What was put to them? And what is the defense? I'll show you one of them, one of the witness is saying,
that is for.
come to page 40. Your witness.
Yes, sir.
What does he say?
I've gone through.
Read it, para 3.
Yes, I've gone through that.
Read it.
On 23/2/1994 night when I came out of our office, I found 5 to 6 bags were kept inside in the roadside and police was there.
This was kept in the roadside and the police was there. Thereafter, I saw the mini truck and which came from, it was lying there in the roadside. The mini truck comes and the defense is, and the police asks these accused person to keep it in the mini truck, which they denied. And this corroborates with this evidence. How will you get conscious position?
Conscious position part is concerned as that the only PW4 in his cross-examination has stated so. So far, PW 8 and 5 to 8 are consistent statement is given.
What they say?
That
Read it.
while they were.
It was asked to them only. They say that yes, we are carrying. That's the evidence you want to rely upon. Then you will ask the accused that it is ganja. Then he will say yes, it is ganja. Then you say that it is conscious position. What is the other evidence you have? Confessional statement of the accused itself is then.
I am placing the statement of the PW 5 to 8 is consistent given the statement that while the present four appellants inside the mini truck and the intervention of the police seized the contraband article from the Dala.
Don't bring stories. Tell me the evidence.
I'm not.
Show me the evidence.
Yes, I'm. That part I am placing the PW statement of the PW 5 to.
Yes, come to page, come to PW 8. 49, second para.
To our query, the accused.
To our query to whom? To the accused, that is the only
That
implication.
right.
To our query, the accused person told that they are carrying husk.
On
So therefore,
I claimed up
that's enough.
to that crime. I am substantiating the PW statement of PW 8. I am relying the PW 5 to also kindly glance.
Let us see the 5. What 5 says. Yes. Read it.
Lordship, I am pressing
5, page
SI
42, last paragraph 1, last 3 line. On the query, they told that they were carrying the gunny bags loaded with in the truck. Exact same sentence. They were asked.
And they were asked on the search of the police personnel, it came to light that he is carrying the ganja. That is the exclusive coming to the exclusive position, Lordship.
No, that is how you derive exclusive position.
Lordship, what happened while the inside there, all the 4 that is put in there, the truck, Lordship.
You read the judgment which is.
Lordship, I am
गोले घंटा इतले evidence हेबोनी. You try to pinpoint. It is a case of NDPS.
No, sir.
Then the strict compliance of section 50. You say that personal search. Where is the once you go for personal search, section 50 is mandatory. Just see, come to PW8. Second paragraph again.
to our query, accused persons told that they were carrying husks. On suspicion, I claimed up to the Dala on the carrier of the mini truck after giving personal
After giving personal
search.
search.
Lordship.
For personal search, what is the requirement?
Here is the case, Lordship.
What is the requirement of personal search?
The officer is authorized to search the Lordship.
Which provision?
That is Lordship. That point of 97, 94 incident, that paragraph dealt in your Lordship judgment. Lordship, that is
Which provision?
Lordship, kindly glance for a moment. Paragraph 2, page 12 of the judgment, last 3 lines, Lordship. Last 4 lines, Lordship. Circle Inspector Atgard is no doubt the empowered officer, according to the government notification so and so. In the present case, the Circle Inspector Atgard PW8 has immediately intimated he is the superior officer, that is sub-divisional police officer.
Where does he say that I have intimated?
That part
I have put. Then
that part is not though.
Then 50 is not complied. 50 procedure is supposed to be complied. Where is 50 procedure? टिके नहीं ये पढ़ेगी कौन तू?
Inspector Atgard PW8.
You can't bring things into the evidence.
So far,
Section 50 is compliant.
55 and 50, I am relying the delay is concerned. The delay is
Now we are in 50.
Yes.
Personal search is done without complying. There is not a semblance of compliance. Two witnesses are required. It was supposed to be put to them that I'll go for search. Do you want an officer to be there or not? Written notice has to be given, and they should say that I have no objection. Thereafter, the personal search. Where is that? Where is that? Once you go for personal search, this is required to be complied.
See, wording is there.
52 capital A and subsection 2 is also not complied. Come to 52 capital A.
The central government may, capital A also. And the central government may, having regard to the hazardous nature, vulnerable to safe substitution, constraint of proper storage space or any other relevant consideration, invested of any narcotic drugs, psychotropic substances, controlled substances or conveyance by notification in the official gazette. Specifically, such narcotic drugs, psychotropic substances, controlled substances or conveyance or classes of narcotic drugs, class of psychotropic substances, class of controlled substances or conveyance which shall as soon as may be after their seizure be disposed of by such officer and in such manner as that government may from time to time determine after following the procedure herein specified.
subsection. Paragraph 2 ରେ ଅଛି।
Okay. Read your turn.
Period order
Read it. Read it.
item 8 is the period order. Any also conviction to the
Item 8.
items.
Item 8 कौन होगा? Period.
Period order. The instruction actually is June 1999 7/5/2028 on the rolling that will say 2008 instruction.
Instruction has come. It's served out. Complete sentence.
After the remission on the remission rule is going to be 10 years here.
Horizon.
30/6/1999 to 5/7/2008. So we have 9 years something.
Oh, along with remission, 10 years. So you tell Avas Manti to come.
Yes, sir.
I'll 2 o'clock I'll dispose it. Okay? Yes. Yes, Mr. Katkia, in which matter?
Okay.
48. Are you ready? Amar ke to chiyo.
After 2 o'clock, I am not available because the
Then you tell me which date. Which date you want? Tuesday? Tuesday? You tell him, ask him which date is. Okay, thank you.
11 already given the
ইয়েটা করা না গরমটা ইয়ে 8 নম্বর উঠছিল না
বুঝতে পারছেন?
আচ্ছা 51
item 8 sir.
no item 8
Item 8
item 8 let's see আমার আবেদন করব 107 he has already undergone
Yes, sir.
9 years something and he has been released after
Thank you.
completion of the then disposal of the deriving out of totally disposition or with Savas Marti and so তারপর লিখিও in order to this what is that the how many appellants are there? One. The appellant was stood charged for alleged commission of offence under section 376 2F. 2F. He took a stance of complete denial and claim trial. And accordingly, he was subjected to trial. Eventually, after the stood trial, the prosecution, in order to prove the case, examined 12 witnesses and exhibited as many as 9 documents. 9 documents. To disprove the case of prosecution, the accused appellant choose not to lead evidence. About PW1, PWK, PW1 is so and so. After appreciation of evidence, the trial court found the accused petitioner guilty of offence under section 376 2F of IPC, inter alia, arriving at a conclusion that the prosecution could prove the case beyond all reasonable doubt. On that count, the appellant was sentenced to undergo
Years imprisonment for 10 years.
RI for 10 years and to pay fine of rupees 10,000 in default of which is further
RI for 1.
to go for 1 year. Has he paid the
No, not paid also. That is why it is written that 714 days remission.
huh?
That is why it is written in the instruction. 714 days. So, say the person they even say the 1 year extra is 11 years for the count.
11 is welcome.
Fine.
At the outset, Mr. Avas Manti, appearing for the appellant, submits that he would not argue the appeal insofar as conviction is concerned. He'll confine his argument to be limited to the question of quantum of sentence. He further submits that the appellant has already undergone the entire period of sentence. When the matter was taken up on 9/9/2025, this court passed the following order: 9/9/2025. Pursuant to the said order, the superintendent of district jail, Jharsuguda, while report dated 18/9/2025, has stated agenda. Reporting agenda. From the perusal of the report, it reveals that the petitioner has not only, the appellant has not only undergone the substantive period of 10 years sentence, but also in lieu of default of the payment of the fine, the 1 year sentence which was imposed has already been undergone by him. Therefore, he has been released from the custody on 5/7/2008.
No, date of release after traveling is 7/7/2008. Last line.
7/7/2008.
Right.
7/7/2008. It is also reveals from the report that he has earned remission of 714 days. 714 days. 14 days. Regarding head to the aforementioned, the submission made by Avas Manti deserves merit. Accordingly, while affirming the conviction recorded by the trial court, the affirming conviction and sentence also, and for the reasons that the petitioner has appellant has already served out the entire period of sentence, nothing survives in the appeal. Accordingly, the same is disposed of.
May I please your lordship? I am in VC, my lord.
Yes.
My lord, day before yesterday, I argued the matter before your lordship, and I have raised that the accused persons have been acquitted from the charge under section 302 IPC and 304B IPC, and the learned trial judge has said that the conviction
Yes.
reduced to
306. 306.
But I have gone through the deposition of the witnesses, mainly the relatives of the deceased, that is brother, mother, and the uncle, that is PW 1, 5, and 8. And from their evidence, I did not find any single word which would substantiate that there was an abetment to the deceased to commit suicide. So, since your lordship knows that in order to attract 306, there must be that compliance of section 107 IPC. That the criteria, as has been held by my lord and referring to the lot of judgments of the Supreme Court, those things have been. Apart from that, I just want to point out certain other things which would also have some bearing on this present case, my lord. The first thing I want to bring your lordship's notice that the death of the deceased occurred on 6/4/2000.
The 6/4?
2000.
6/4/2000.
Okay.
The death of alleged incident.
Yeah.
So PW7, who is a prosecution witness, my lord, he informed the police station at the police station
Yes.
regarding the information that deceased has committed suicide. He is a
PW7 is the informant.
PW7 is the first informant. He gave a information that regarding death of the deceased, that she committed suicide.
First of all, UD case was registered.
Yes,
because some-
just I'm coming. A UD case was registered on the basis of his information. Yeah, and another point, my lord, is coming that PW1, who is none other than the brother of the deceased, he has said that while when they got information regarding the death of their sister, they were coming to the village, and after seeing the dead body, they went to Mangalpur police station, and their uncle has given a report. That report, even if it is raised before the trial court, that report was neither called for nor during investigation it was unearthed. So they are the relatives.
Might be referring to the same UD case report.
No. They have given a report at Mangalpur police station. Your lordship may kindly come to evidence of PW1. Kindly come to evidence of PW1.
Mangalpur police station report has not come on record, huh?
Yes, that has not come on record. And why that has not come on record? That is, and the learned session judge has said, the trial judge has said, since there is already an FIR, any subsequent statement may be a. But this UD case was turned to a police case after about a month. That is after receipt of the postmortem report.
When this case was registered?
This case was registered in May. The death occurred on 6/4/2000. This case was registered on 27/5/2000. That is after receipt of the postmortem report.
Then this case was registered on 27/5/2000 on receipt of?
That is after about 1.5 months. And the relative who have lost the information, that is on the same day, on the death of the deceased.
Okay.
That report was not there. That also creates a doubt. What was that report? Whether there was any torture or any allegation made by the relative of the deceased at the first instance.
This is the PS case number?
This is PS case number. This is Exhibit 1 is the FIR.
Which police station?
That is just 1 minute, madam.
Mangalpur.
Yes. Mangalpur PS case number 38. Yeah, on the same police station, my lord. On the same police station, your lordship may kindly see evidence of PW1 where he has admitted that his uncle, while returning from the village, has given a report. Your lordship may kindly come to para 8 of PW1 deposition. My lord, got it?
Yes.
May I read, my lord, para 8 of PW1?
Yes.
Mangalpur
Yes,
PS is about 3 kilometers away from my house. Accused person's house is about 15 kilometers away from my house. Mangalpur PS falls on the way. While coming from the house of accused person to our house, we did not make any report.
After returning from the house of the accused
Yes.
person, we informed the police in writing
Yes.
in Mangalpur PS.
Yes. That is not there. That report is not there.
So
Rather,
this FIR was registered not pursuant to this report.
not pursuant. This FIR was registered pursuant to the report of PW7, whereupon a UD case was registered, and after receipt of the postmortem report, Then this case was turned by to a police case, and the same person who converted the same persons has investigated into the matter.
That is PW 7.
No, PW10.
And this, according to you, the PS case 38 was registered after UD case report.
After UD case, on the basis of UD case, after conclusion of the UD case, this PS case number 32 was registered. But so far that report submitted by the uncle of the deceased was not brought on record.
Can you tell me UD case number, anything?
It is UD case number, I'm just
PW 7, let's see.
Exhibit 6 is the UD case.
Exhibit 6.
4 of 2000.
Exhibit
4
6,
of, 4 of 2000.
4 of 2000.
4 of 2000.
Exhibit 6.
Yes.
Yes.
Exhibit 6.
That is lodged by PW7.
So this Mangalpur PS report, as it is occurring in para 8 of PW1,
Yes.
is not on record.
Not on record. Not on record.
Okay.
And that is a separation. And my lord, another thing. Postmortem was conducted. The dead body of the deceased was sent to the district headquarters hospital, Jajpur. My lord, PW4 is the doctor who conducted the postmortem. Again, the dead body at a decomposed stage was sent to SCB Medical College Hospital for further postmortem and that was conducted by the assistant professor of FMT. And although the doctor has admitted that all facilities are available in that hospital, nothing, and why it was sent, that is nothing.
Okay.
And so far, PW8, 4, 1, 5 and 8 are concerned, my lord, regarding this dowry demand, rest of the dowry demand of 5,000.
PW1, 1, 8.
1, 5 and 8. They are
5
the
and
three, 1, 5 and 8. They are the three relative of the deceased, my lord. Now, one is brother, 5 is mother, 8 is uncle.
Yes.
And all the three witnesses, my lord, your lordship would find that they have contradicted in material particulars so far the dowry demand is concerned. They have said that they have in looking to their evidence confronted with the IO, it appears that they have not actually stated all these things regarding demand of dowry specifically.
Yes.
So, my lord, what I beg to submit, my lord, PW4 has 4 the doctor conduct the district headquarters hospital doctor has conducted that the ligature mark appearing on the neck of the deceased as a case of hanging, my lord. And there is nothing about the injury, and some injuries are postmortem. The body was at a decomposed state. Why it was sent at such a belated stage to the doctor? That is also not explained by the prosecution. And there is nothing on record regarding the abatement.
Then 113 is also not.
113, it cannot be placed into service.
The court says that the presumption will not operate against you.
Yes.
No, the court says that the presumption operates.
Yes.
Having said that,
having said that, he reduced but that is also not applicable, my lord. That cannot also be placed into service. And my lord, last time your lordship said that even at this stage it can also. But I afraid, my lord, that the charge was 34 is that. There is no independent charges. All accused persons were charged under section with the aid of 34. Now 2 accused persons having been died. So even at this stage, the remanding a matter, it also will also not work, my lord.
Okay. Manju Jena, the appellant number 3 is the sister-in-law.
Sister-in-law.
Okay.
No, Manju Jena is dead, my lord. Sorry. No. Jitta Jena is dead. Manju Jena is the sister-in-law, Dinabandhu is the husband, and Chandramani is the brother-in-law. Durjodhana and Jita are dead.
Chandramani is the brother-in-law.
Chandramani is the brother-in-law.
brother-in-law,
Yes, madam. Yes. Brother-in-law means
Europe.
Europe. Younger brother of the.
Okay. What are the specific allegations against Manju and Chandramani?
No specific allegation. There is
General.
the allegation is that they were demanding, Duryodhana was demanding, Chandramani was demanding, Jita was demanding 5,000 rupees and threatening that if that 5,000 rupees is not, and that is also contradicted by and not stated during their statement recorded that has been put to them in their cross examination.
Yes. Okay. Yes, madam.
Yes. Chief, on the, I understand the arguments advanced by the learned senior. Your Worship. There are two things I would like to point out. First of all, the discrepancy.
Mike.
Am I audible? The first thing, whether there is another report which was lodged, allegedly report before the Mangalpur PS. That's not nothing, no bearing on the pointed issue. The marriage took place in July 1998 and she died on 6/4/2000. Your Lordship. Accordingly, on 6/4/2000, one UD case was registered as 4/2000, which was Your Lordship, Learned Senior has rightly pointed out, after the PM report that is converted to 302. Your Lordship. That is how the entire criminal prosecution was launched. Now I have to just show whether there is a live link between the instigation or abatement and the death of the deceased. Your Lordship. That is the entire crux solution. So I'll be relying upon one judgment. This is a recent judgment of December 2024, Prakash versus State of Maharashtra.
You have the copy.
I'm just requesting
Huh?
I'm just requesting for a hard copy. Your Lordship.
Copy देखो.
What's the reference, please, ma'am?
So Prakash versus State of Maharashtra,
Speak a little louder.
20th December 2024.
Has it been reported?
I've not checked up, but I was getting ready for the item 43 and that was called. So that is how I got off. Worship, in this session, the Honorable Apex Court.
What does it say?
Pardon me, Worship.
What does it say?
It says there should be a live link between the instigation, abatement, as well as the consequential suicide, Your Lordship. Now I have to just show that whether there is any act on the part of the accused which led the deceased to commit suicide. Because as Your Lordship on the other day pointed out, there are clinching materials on the part of the prosecution which enforce regarding the 304B. However, he has been convicted under 306. I'm conscious that state has not filed any appeal. So I'm arguing in 304B will be futile. I'll just show the link between the.
Very interesting finding. It says that.
Yes, sir.
113.
Yes.
Very interesting finding.
Conscious, sir. And admittedly, state has.
In the face of this finding, you should have challenged that.
Absolutely, should have been. In fact, even the evidence of the doctor and the first doctor who conducted the PM, he said there is a suggestion that whether it can be hanging. He said yes, it is possible that the injury is reflected in the body, the ligature mark on the neck and the thyroid. It could have been possible by hanging. But however, state has not filed any appeal to that effect. So I'll be confined myself to 3%.
How she has died? The hanging.
Hanging.
Who found him? Hanging? Any witness?
It is the burden under section 106 since she died at the house.
In the house.
The house. And by the time these people and the relative of the deceased, these guys met the deceased in the hospital.
No, who had taken her to hospital?
Accused, husband.
Husband.
No, not husband. That father-in-law.
There are many persons.
Father-in-law, Duryodhana has taken her to the hospital.
Let us see who is died now. You are showing this judgment now?
Yes.
Let us see which part.
They have quoted and discussed other judgment also. I'll be.
Madam, what is the date of that judgment?
20th December 2024. 2012, 2025. Yes, sir. The discussion has started from paragraph 16, Your Lordship. 15.
Para 15.
15, Your Lordship. Page 5. At the bottom, Your Lordship may kindly see the.
Page 5, huh?
Page 5.
Okay.
Lordship, I'll be placing page 6, Your Lordship, 25, may I?
Huh?
Your Lordship, may I kindly see page 6 of that judgment, Your Lordship. I'll be placing.
P6, okay.
Page 6.
Yes. 25. Abetment involves
Yes, Lordship.
mental process.
Yes, Lordship. Abetment involves a mental process of instigating a person or intentionally aiding a person in doing of a thing without a positive act on the part of the accused to instigate or aid in committing suicide. Conviction cannot be sustained. The intention of the legislature and the ratio of the case decided by this court is clear that in order to convict a person under section 306 IPC, there has to be clear mens rea to commit the offense. It requires an active act or direct act which led the deceased to commit suicide, seeing no option, and the act must have been intended to push the deceased into such a position that he committed suicide, Your Lordship.
Yes.
Yes. Thereafter, I'll be placing over the page 7, Your Lordship.
17 also. Next paragraph also you can read it.
Your Lordship,
See,
beyond paragraph
this court
15,
held.
they have discussed.
This
They have
court held that abetment involves the mental
held that the
process
abetment involves a mental
of
process of instigating a person or intentionally aiding a person in doing a thing. Therefore, without a positive act on the part of the intentionally aiding a person in doing a thing, therefore, without in committed, the conviction cannot be sustained. This court further observed that the intention of the just my daughter, accused Duryodhana left our house immediately. There is a
marriage.
not to detain my daughter, to send her after arranging the rest amount. The accused Chandramani stayed in her house for about 4 days. While leaving her house, the accused Chandramani also asked us to send my daughter after arranging the rest amount. We could not arrange the rest amount, and Pabana took my daughter to leave her in her marital house. Accused Chandramani and Sanju refused to allow my daughter to enter into Sanju, Your Lordship. Again, he corroborates the PW1 statement. Accused Chandramani and Sanju refused to allow my daughter to enter into a house as the dowry could not be arranged. While my daughter and after returning at Chandramani and Sanju threatened to kill my daughter by stone.
Very specific, Chandramani and Sanju.
Yes, Lordship. Accused Duryodhana and his elder brother.
Sanju? Sanju is not there. No one.
Sanju, Your Lordship.
Sanju is appellant number 2.
Your Lordship, that is Manju.
Sorry, appellant number 3.
3, Your Lordship.
Sister-in-law.
May I continue? To kill my daughter
Not
by
Sanju,
stone.
Manju Jena.
Manju, Your Lordship.
Sanju.
Accused Duryodhana and his elder brother's wife asked my daughter to leave in the house, stating that they would settle the matter. Thus, my daughter stayed there. On the next day, Pawan alone returned. After 2 days of the departure of the Pawan from the said house, we came to know that the death of my daughter. So again, he corroborates the PW1, which stated that the preceding 3 days he was subjected to harassment and demand of on the non-fulfillment of dowry. That is how she died. In the cross-examination, he states about the injury found on the person of the deceased, which may not be relevant.
In the cross-examination, let my learned friend place that portion that where she says that for the first time I am saying all these things in the court.
But let her complete.
I'll just place in the cross-examination. He says, she says, my daughter complained about the torture to me, my husband. No other person was present when she complained about the torture before us.
Yes.
Thereafter,
for the first time, I am narrating.
PW6, Your Lordship. PW6. Paragraph 3 at page 2, Your Lordship. I'll just read the relevant portion.
Who is PW6?
PW6 is the...
He is a co-villager of the accused person turned hostile.
He was present at the time of settlement, arrived within the party solution. In paragraph 2, he said, I was present when the marriage proposal was settled. On the request of Duryodhana, father-in-law of the Gedi, I went there. My nephew Madhu Chatta was also present. It was settled in the house of Gedi and so on. So thereafter PW7.
PW6 has not said anything.
Yes, it won't be of a
There
much
was no
help.
talk of demand of dowry. And
He was
that-
only present at the time of settlement of the marriage. He said
Hostile.
he
Yes.
did not report any ownership. I'll start with
PW7.
PW7. I know the accused persons. Gedi's marriage with the accused Dinabandhu was held about 7 years back. Gedi committed suicide. Thereafter,
He informed the police.
in fact, he informed the police that apart from that, there is nothing much to support your worship. That's PW8. I know all the accused persons. Gedi, my niece, had married the accused Dinabandhu in the month of Asada in 1998. Accused Dinabandhu's father Durjodhana and accused Chandramani demanded to give a sum of rupees 10,000 as
Who is
dowry.
he?
He is the uncle of the deceased.
He is the Dada.
Uncle.
He's Pawan, huh?
Pavan, your worship.
Okay. PW8 is Pawan.
8. Accused Dinabandhu's father Durjodhana and accused Chandramani demanded to give a sum of rupees 10,000 as dowry in connection with the marriage of Gedi. My brother Gaganjana is the father of the deceased. Your worship. My brother Gaganjana agreed to give a rupees 5,000 before marriage and he assured to give the rest amount after the marriage. I was present when the dowry amount was settled. 3 days before the date of marriage, I myself gave a rupees 5,000 to the accused Durjodhana in presence of Baju Jena in the house of accused Dinabandhu on the day of Svikara. That apart, as per the demand, Durjodhana and Chandramani, gold bangles, 8 pieces of swansa were also given at the time of marriage. Then paragraph 3. Gedi led a happy married life in her husband's house for about 5 months. Thereafter, Gedi informed that the accused persons were harassing her as the rest amount was not given as per the demand made by them. After 5 months of her marriage, Gedi returned to her house alone because the harassment caused by the accused persons. She informed us about the demand and harassment during her stay in her parents' house. The accused Durjodhana alone came and asked to give the rest amount. Thereafter, the accused Dinabandhu also came and asked to give the rest amount. I left the Gedi in her matrimonial house, requested the accused Durjodhana to allow us to give give the rest amount later. One day before the date of marriage of my brother Robbie, I went to bring Gedi, but the accused Durjodhana did not allow her to leave the house, stating that he would send her on the date of marriage of Robbie. On the date of marriage, my brother, the accused Durjodhana and Chandramani came with Gedi to our house. Accused Durjodhana left the house, warning us not to detain Gedi and the rest dowry amount immediately. Accused, I cannot read because it's invisible. Accused once in our house for 4 days and he accused Chandramani. Please. Accused Chandramani and deceased stayed in our house for 4 days and he also warning in the same manner as given by the accused Durjodhana. Thereafter, at the time of marriage of Robbie, I left her in the house of the accused persons. Being asked about the rest amount by the accused Jitu Jana, I told her to give the dowry amount before Raja festival. Accused Chandramani further threatened telling that they would kill Gedi by means of stone if the demand was not fulfilled. They have asked me to take Gedi. While I was returning along with the Gedi, accused Durjodhana and his sister-in-law interfered and requested me to leave Gedi there and not to get annoyed. I stayed in the night and returned on the next day, promising to give the dowry amount before Raja Sankranti. After 2 days of my departure from their house, my brother Gaganjana informed me that Golokajana informed me that Bolunga Chokka that Gedi had expired. On the next day, I along with the Swansa, this is the live link between the suicide committed by the deceased and the harassment committed by the accused person. Lordship, in the cross-examination also, he states.
But
Completely gave a new story.
Para 4.
But
Para 4 of the PW8.
yes, sir.
Last portion he read on the way.
Yes, sir.
Immediately after the
On the next
death
day,
has occurred.
pardon, Your Worship.
Immediately after they came to know that the death has occurred,
Yes, sir.
on the way, para 4, just if you read,
Yes, sir. After 2
on the
days
next
of his
day,
departure,
I along with so and so, so and so, so and so,
Ravindran Swanson,
went to the house of the
accused persons
person.
on the way,
On
my
the
brother
way,
that is exactly
my
what the
brother
learned senior was
informed
saying.
police.
Yes, sir.
Yes.
On the way means immediately.
Yes, sir.
And
That
that report is not available on record.
It may not
That would
be-
have been the, see, in particularly when the GR case was registered, date.
That is in the month of May, 1 month, 1.5 months after the incident.
Yeah, UD case, sorry, UD case.
UD case was registered on the same day, on the date,
On 6/4.
on that 6/4.
27.
6/4,
UD case.
6/4, the UD case was registered.
Let us see exhibit 6.
Yes, sir. To the OIC Mangalpur PS.
କଣ ଲେଖା ହେଇଛି? ପଢ।
ମହାଶୟ ନିବେଦନର କାରଣ ଏହିକି ଯେ ଆମ୍ଭେ ନିବେଦନକାରୀ ଗୋଲେଖ ଚନ୍ଦ୍ର ଜେନା ପିତା ସୁଆଂଶୁ ମଙ୍ଗଳପୁର ଜଣାଉଅଛି କି ମୋର ଭାଇ ବୋହୂ ଶ୍ରୀମତୀ ସବିତା ଜେନା ସ୍ୱାମୀ ସୁଆଂଶୁ ସମୟ ପ୍ରାୟ ଦିନ 12ଟା ହେବ ଆମ୍ଭେ ଭାଲୁଆ ବିଲରେ ଧାନ କାଟୁ ଖବର ପାଇଲୁ ଯେ ଭାଇ ବୋହୂ ରସି ଲଗାଇ ଆତ୍ମହତ୍ୟା କରିଅଛି। ଏଣୁ ଅନୁରୋଧ କରିକି ତଦନ୍ତ କରି ଶବ ସଂସ୍କାର ପାଇଁ ଅନୁମତି ପ୍ରଦାନ କଲେ ଆମେ ଚିର ଉପକୃତ ହେବୁ। 6/4/2011।
Who is written? Chandra, who is this? Sri
Golok Jena.
Chandra Jena, Your Lordship.
Golok, he has been examined.
Yes, PW7.
PW7.
Yes.
PW7.
What does he say? Let us see.
He says, I know the accused person so and so. I informed the police. I'll placing paragraph 2. I was in my field. Being called, I came to the house of Gedi and saw her dead body in the house. Her mother-in-law, father-in-law was present by the side of the dead body, and other accused persons are not there. I informed police in writing, which was written by Devendra Kumar Christie as per my instruction. Exhibit 6 is my report and Exhibit 6 is my signature. I went to the Bolunga Chakko. My maternal uncle, I requested him to inform to the family members of the deceased.
And he says Dinabandhu was not there.
Since it is 306, whether that particular presence at the time of occurrence immaterial.
Yes.
Worship, PW8, I'll be placing
Read PW8 over here.
again.
PW8 I have read.
Worship. In paragraph 9 also, Worship, in paragraph 7, 8 and 9 in cross-examination, he rated as the same thing.
I got it.
Worship.
Yes, Mr. Acharya.
Yes. Around
See,
PW.
what is the prosecution case is
Yes.
immediately preceding the suicide.
Yes.
There are some incident because the brother of the deceased was to marry, and she went there. There the demand was made, and Pawan came to drop her.
Yes.
And something happened there.
Chandramani Durjodhan also.
Chandramani and the two, Manju and Chandramani has demanded specifically. Thereafter, the suicide has taken place.
They did
No,
not
So
allow
the
to enter
conduct,
the house.
continuous conduct of the accused persons.
Not,
is-
my lord.
is
No.
the abatement. Is
My
the
lord,
abatement.
it is not there, and it is not specifically mentioned, my lord, that on which date the deceased was left.
No, this is, see, exact date is not required. Marriage was there.
No.
Brother's marriage, 2
That-
days.
No,
2
that
days
is,
thereafter, and all of them are saying that she stayed for 4 days in their house. After 4 days, she was about to, she was left along with Pawan. Pawan came to your house, and you said that unless you get the money, we will not allow you.
my lord, that is what,
That part of the evidence, is consistent.
my lord, that your lordship may kindly see that the IO evidence, your lordship may kindly see that part is contradicted. For the first time they are saying. Your
But in the
lordship may kindly see
cross-examination,
PW10 cross-examination, where it was put that demand is not there.
Come to
PW10, your lordship may kindly see where it was confronted and these contradictions were confronted to the PW8 and PW1
I'll be
and
placing.
PW5 says admitted that for the first time I am saying all these things.
No, come to
May I?
10.
On 27/5/2000, I was posted as SI.
Your lordship may kindly see PW10 paragraph 9.
Yes.
There are two IOs. Another IO has not. I don't know why he has not been examined. I was examined on examined Pabbani on 8 PW8. He has not specifically stated that he himself gave a sum of rupees to accuse Duryodhana and presence of Bajajana and Shikar. He has not specifically that the accused Duryodhana came to his house for 5 months after the marriage, and when Gedi was present in our house and asked
I'll start with the paragraph 4. May I read, your lordship? I examined PW9 Sibo. He stated before me that in his presence from the side of the bridegroom,
PW9 is a hostile witness, my lord.
May I please? May I please, your lordship?
No, but he is a hostile witness.
Demanded as
His
dowry,
evidence
and
is of
Gedi's
no
father,
value.
One minute, sir. Yes.
agreed to give up rupees 5,000 before marriage and agreed to give the rest amount after the marriage.
Where are you reading, madam?
Paragraph 4.
He referred to his 161 statement. What he has stated, that is not admissible, my lord.
Yes.
That after the marriage, since the family members of the accused and the accused himself forced Gedi to bring the rest amount, Gedi left the house and went to her parents' house. And that 2 to 3 days prior to her death, Pavana Jana had left Gedi in the house of the accused persons and they had refused to accept Gedi as the demand was not fulfilled. But subsequently, they allowed her to enter into the house, and that after 2 to 3 days, they came to know that about the death of the Gedi. I'll just, ASI Brundaman conducted the inquiry in the UD case number so and so. Thereafter, the cross-examination, your lordship.
Yes, that part is also, he says.
That is a, my lord, that is a statement which he has made before him. That is not admissible. Once referring to the 161 statement, he said. He is a
Para 4 you read. Para 4 he says.
Para 4 he says that is the IO statement what PW6 has said before him.
In paragraph 8.
My lord, your lordship, I am reading again, my lord.
The same thing, whatever they've said in 161 has been repeated in their testimony.
No. PW9 has not has been turned hostile.
Maybe. That story is
how he's 161?
Paragraph 8.
No. My lord, he has turned hostile, and he is.
Allow me to complete.
Yes.
Who has turned hostile? Who has turned hostile?
PW9, PW6 and 9 turned hostile. Their 161 were confronted to the IO by the prosecution. So that how that 161 will be can be used as admissible evidence.
I'll address to that. Before that, I'll be placing paragraph 8 of the IO lordship. I examined PW2 Chittaranjan. He has not specifically stated that the dowry amount was settled in the house of Nanda Sahu. He has not stated specifically that the 5,000 would be given at the time of Swanso. And she came to her parents' house and informed me that in-laws were abusing Sadhu. I examined Pabani, PW8. He has not specifically stated that he himself gave us rupees 5,000 to the accused Durjodhana in presence of Babujana, and that was Svikar. Thereafter,
he has not specifically stated that accused Durjodhana came to his house 5 months after the marriage when Gedi was present in her parents' house.
Nothing in the cross-examination. Cross-examination again, confront he nahi kitchen hai. And PW9 do sir ko this place. PW9, I'll restate the paragraph 3 again, your lordship.
PW8,
yes,
whether this was confronted?
Yes, my lord. Paragraph 9 of the IO deposition, your lordship may kindly see. Paragraph 9 of the IO deposition.
PW10.
PW10. May I read, my lord? Your lordship got it.
He said he has not specifically stated regarding the.
Yes, that is what, how is the confrontation is made to a witness. It was put to the witness.
I'll be placing paragraph 9 again. I examined Pawan of PW8. He has not specifically stated that he himself gave a rupees.
Where are you reading?
Paragraph 9 of the IO, PW10.
No, that I read.
Your lordship.
I'm in paragraph, PW8 I'm seeing. What are the suggestions put to the?
Yes, your lordship, I am coming to PW8.
The cross-section starts from paragraph page 4.
My lord, your lordship may kindly see page para 7 of his deposition. Para 7. Police examined me twice. Your lordship got it. PW8 para 7.
Read it.
Police
Next
exam.
in between read it.
My lord, I'm
Abdul
reading.
Chandramani and Manju further threatened that they would kill Gedi.
No, your lordship may
With
kindly.
the demand of not fulfilled. They've asked Brigadier so.
Paragraph 9 of the paragraph 9 of the cross-examination of the PW8. On 2 occasions, I left Gedi in her husband's house. Gedi informed me that the torture in the presence of Robbie, Gogana, Dhirendra and so, but I cannot
And
say.
he says that I stayed in the night and
Yes.
returned in the next day.
Yes.
Telling to give the dowry money before the Raja Sankranti. That after 2 days of my departure from the said house, the brother Gagan Jena informed that the Golok so died. He is also in the cross examination also he is consistent.
So,
My lord, what I beg to submit, my lord, it could have been a dowry death case. This is evidence is taken that how, but then how, where is the question of abatement, my lord?
That's what he says. Abetment is consistent conduct.
Your lordship may kindly see. He has given an assurance that by Raja Sankranti they will. If that is a assurance, then why the accused persons will torture the deceased?
But the humiliation meted out to Pawan, his uncle, that may be reason. See, this is all mental state.
No, my lord, there
Not necessary that
there was a suggestion to the witness that he came in a drunken state that caused humiliation to the
that
deceased.
suggestion was denied.
that suggestion was denied.
That suggestion was denied, might have been denied, but that was the reason.
Your lordship, may I sum up?
And your lordship may kindly see even if the assurance was given, my lord, then why that is not a torture, my lord. That can lead to a demand of 498A or 4 DP Act.
No,
But how can it be
we are examining where there is any abatement.
abatement? How can it be
Provocation. Provocation to take the extreme step.
No, my lord.
Because the humiliation meted out to her,
my lord,
immediately before the death.
What?
Is such.
No, it was not. She was not humiliated, my lord. She is the people were demanding the amount that the demand was right from the date of marriage.
She went to attend the marriage of her own brother. Remained for 4 days. Immediately after 4 days, she was demanded dowry.
And my lord, your lordship may kindly see.
And the uncle came to drop her.
My lord, your lordship may kindly
he was humiliated. And all these things led to the provocation.
Where is the evidence that she was humiliated? There is nothing on record that she was humiliated.
After 2 days, after Pawan left.
There is nothing on record that she was humiliated. And your lordship may kindly say, PW1, the brother, says, on every occasion I have gone to the house of my sister, I was treated properly. And your lordship may kindly see PW5, mother, they were treated properly. There was no dissension.
Maybe they were treated properly. That's a different thing altogether.
And they were these relations were treated properly, but they were treating ill-treating the deceased.
May I sum up?
The only thing which is there in your favor is the large part of the allegations are general allegation.
Yes, general
omnibus
allegation.
This is
That
the
is a
only
gen-
thing which
that is a
is
general-
somehow
Well,
tilted towards you.
That is a general allegation, my lord.
That's the only thing, except
That
that
is-
I don't think there is anything.
Yes, yes, that is a general allegation.
Two things. sir.
And my lord, that another thing, I think it's a case of 498A. I don't say that it is not a 498A. 498A and 4 DP Act is there. But
Then that's what she says. The 498 you concede. Then for the purpose of 498A, you that led to commission of.
306 cannot come, my lord. 306.
How much you have undergone, by the way? You tell me.
My lord, that is about 2.5 months.
What is the sentence?
3 years.
Minimum sentence. 306 program minimum sentence.
There is no minimum, my lord. There is no minimum. There is life imprisonment is also there.
Punished with either the description of term which may extend to 10 years and
Like-
to be liable to fine and
There is no minimum sentence, man.
maybe extendable to 10 years.
Even 498 is the same thing. Huh?
Yes, ma'am. But as
3 year sentence is given. Huh?
yes,
3 years.
Even the explanation A and B of the 498 is a good play in this case.
my lord, but
Explanation.
498A.
Explanation to the 498.
Ek minute. Let us see.
the DC, the torture of the such nature that will drive a woman to commit suicide.
May I?
Yes.
Whoever being the husband or the relative of the husband of a woman, subject such woman to cruelty shall be punished with the regular so-and-so. Explanation. The purpose of this section, cruelty means any willful conduct which is such a nature that is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb or health, whether the mental or physical of the woman. Harassment of the women where such harassment is with a view to coercing her to any person related to her to meet any unlawful demand for the property or valuable security.
If it is falls under exception A, then 306 is must. If it is falls under 2, then there is a chance of.
But my lord, it is not falling under the exception 1.
No, then it is this cruelty led to commission of suicide.
So that is not the exception, that is the explanation.
Explanation.
That is not there. ma'am.
No, the cruelty as occurring in 498 is made out according to you.
Yes.
Then that led to suicide.
No,
That's
no,
what.
that is not made out, my lord. My humble submission, because your lordship may kindly see their statement is inconsistent with their previous statement and coupled with the fact that there is a suppression of the FIR. Why that FIR has been suppressed? What actually, my lord, what?
This is one. See, this is one limb of argument. That doesn't mean that the consistent statement
No,
of
my lord,
all the witnesses can be thrown.
your lordship always appreciated in other cases, not the honorable court and the apex court, that when the first information, the PW1, PW8, consistently they are saying that they on their return to their home, they lost a FIR. They gave a FIR. What is
I
that
can
FIR?
understand if GR case would have been registered subsequently.
No,
GR
no, my
case
lord.
is the same day.
No, not
UD, sorry, UD case is same day.
UD case was registered on the base on the
And in the UD case, it is very expressly said suicide.
yes, I understand, my lord. That is from our side. We have reported. That is my
And
job.
after inquiry and all, it
My
was
lord-
found that the suicide has been caused because of the harassment.
My lord, may I sum up the thing? My lord, the person who lost the information, that is PW7, he is my brother of the accused. He said my Bhaibo has committed. From our side, we immediately informed the police and informed the family member of the deceased. It is our conduct must be seen, my lord. And they say that they are also immediately gone to the police station and reported a matter. What is that? What was their allegation at the first instance? And my lord, another thing. Let my lord friend kindly please allow me to speak. My lord, another thing, my lord. There was every facility was available in the district headquarter hospital. Why the doctor said that the dead body was again sent to the VA, and the person who registered the UD case inquired into the, and he himself has conducted the lost the FIR and conducted the investigation. He is the IO. Definitely he will be interested. Well, he, in order to suit the prosecution, he prepared the things. Well, all these things has not been taken note of by the trial court, and trial court abruptly jumped to a conclusion without recording any finding that offense is reduced to 306. How it can be reduced to 306? But he has to, in order to say that, he has to discuss all these things.
And 313 also you have not said anything.
313, nothing was asked.
Your Lordship,
No,
Nothing was
everything was
asked.
put to you.
Lordship, my exhibit 7 would be relevant.
7.
Exhibit 7.
What is this?
Certified copy of the order passed in OJC number 4356/2000.
What is
That
it?
would
That is again regarding that FIR lost by them.
Your Lordship, I'll be placing exhibit 7 and 8 for a minute.
What is the order?
Pardon me.
Who has filed this filed by?
4/36.
Gagan Jena, father.
Yes,
Father has filed this. What was the prayer?
The prayer is at page 85 of the liquid brief, Lordship. Therefore, it is prayed that this honorable court may graciously be pleased to issue writ of mandamus.
Why
by
the
directive
written
of-
report dated so and so, so and so?
It is not yet registered. And the written report is at page 87, Your Lordship.
87.
That was
87.
not brought on record, my lord.
Now, that is how it can be explained, Your Lordship.
87.
87. That answers the query made by the.
Where is that 87?
Page
Annexure?
87 of the liquid brief, Your Lordship.
Hmm?
Page 87 of the
Nical that.
liquid.
TCR.
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 Yes, Lordship.
This one, huh?
Your Lordship got.
What is it written?
Lordship, that the date is written on the bottom of the page, Your Lordship.
13/3/2000.
Your Lordship, may I read?
हाँ.
ଭାରପ୍ରାପ୍ତ ଅଧିକାରୀ ମଙ୍ଗଳପୁର ଥାନା ମଙ୍ଗଳପୁର ମହାଶୟ ନିବେଦନର ଅଭିପ୍ରାୟ ଏହିକି ଯେ ମୋର କନିଷ୍ଠ କନ୍ୟା ଶ୍ରୀମତୀ ପାର୍ବତୀ ଓରଫ ଗେଡି ଜେନାକୁ ମୁଁ 1998 ମସିହା ଆଷାଢ଼ ମାସରେ
You are reading somewhere else.
Lordship, that is the written report. That is the written report given by the relative. of the-
Immediately after this affidavit.
Page 87 of the TCR, Your Lordship.
87. निकालो भाई,
87.
क्या दिखा रहे हो? This is 87. निवेदन यही कीजिए मोर कनिष्ठ कन्या श्रीमती जेना सुनसु
ଗେଡି ଜେନାକୁ ମୁଁ 1998
सेकंड पैराग्राफ रीड मोरो साना भाई
ମୋର ସାନ ଭାଇ ରବି ଜେନା ଗତ ମାସ 13/3/2000 ବିବାହ ପାଇଁ ଗେଡିକୁ କମାରଡିହିରୁ ଆଣିଥିଲି। ଗତ ସୋମବାର 3/4/2000 ତାରିଖରେ ମୋର ମଝିଆ ଭାଇ ଅତର ଜେନାଙ୍କ ସଙ୍ଗେ ମୋର ଝିଅ ଗେଡିକୁ ତାର ଶ୍ୱଶୁର ଘର କମାରଡିହିରେ ଛାଡି ଆସିଥିଲା। ଝିଅକୁ ଛାଡି ଆସିବା ସମୟରେ ମୋ ଝିଅର ଦିଅର ଶ୍ରୀ ଚନ୍ଦ୍ରମଣି ଜେନା, ଶାଶୁ ଶ୍ରୀ ସଞ୍ଜୁଲତା ଜେନା ଓ ମଞ୍ଜୁଲତା ଜେନା ମିଶି କହିଲେ, ତୁମ ଝିଅକୁ ଏତେ ଦିନ ହେଲା କାହିଁକି ରଖିଥିଲ, କାହିଁକି ଆଣିଲ? ତୁମ ଝିଅକୁ ନେଇଯାଅ। ଯଦି ତୁମର ଝିଅକୁ ନ ନେଇ ଯାଉଛ ତେବେ ତାକୁ ପଥରରେ ଛେଚି ଏଠାରେ ମାରି ଦିଆଯିବ। ଏହାପରେ ମୋ ମଝିଆ ଭାଇ ଅତର ଜେନା ସହ ସେମାନେ ମିଶି କଳିଗୋଳ କରିଥିଲେ। ଏହି କଳିଗୋଳ ସମୟରେ ନିକଟସ୍ଥ ଗ୍ରାମବାସୀ ରୁଣ୍ଡ ହୋଇ ସେମାନଙ୍କୁ ତିରସ୍କାର କରିଥିଲେ। ମୁଁ ଝିଅ ବାହାଘରରେ ଯୌତୁକ ବାବଦ 10,000 ଟଙ୍କାରୁ 5,000 ଟଙ୍କା and so on. So
this is the complaint given in Mangalpur.
the
My lord,
written
my
report
lord,
by the
may I
relative
And a
answer?
writ
not
was filed.
registered, which was not registered. That is why they approached this honorable court in a way of OJC, and upon the direction of this honorable that the FIR was registered on 27/5/2000.
Register on the basis of which report? Not on
This
the basis
report
of this
6/4/2000.
Not on the basis of this report. My friend is unnecessary bringing that fact, my lord. How annexed to the writ petition?
No,
and
this
which
is
has been-
no. See, the UD case is registered. That is UD case is Exhibit 6.
Yes, and UD case was transferred.
And part of annexure in the writ petition is Exhibit 7. Part is that Mangalpur police station.
That is not registered, my lord. Your UD case, your lordship may kindly see.
That is not registered. Therefore, a writ was filed.
The writ was filed, but my lord, your lordship may kindly see that was the original report was not brought on record. Rather, the UD case FIR which was done.
No, but you said it has not seen the light of the day is not the case.
No, my lord, that is,
Rather, the father of the deceased has brought it to the court.
my lord,
High Court by way of writ petition,
my lord, just a minute, my lord, allow me 2 minutes, my lord.
which has been exhibited now.
No, my lord, that is not exhibit, my lord. Writ
Exhibit
petition.
7.
Exhibit 7 is the writ petition. My lord, annexure appended to
In the writ petition, this was the annexure.
This was the annexure, but that was why that was not registered, despite the direction of the honorable court. If that was the actual report,
And
that
these are
was,
not.
there is nothing. My lord, how things which was not registered and not a part of the charge sheet can it be pressed on record at the time of appeal, my lord? My lord, my learned friend is that is not the jurisprudence of the criminal law. A thing which was part of the writ petition, annexure of the writ petition, and that has been exhibited. Despite the direction, your lordship may exhibit 7.
Kindly see the counter affidavit filed to the writ petition.
My
In
lord,
part
that is, your lordship may kindly see the direction of the honorable court in the OJC.
Para 3, the counter, the police inspector has said.
Exhibit
That was converted to UD case.
UD case was converted to a PS case, not this case. And how can my learned friend will rely on that?
Does it have a bearing on the point at issue at this stage?
Yes, definitely. What was that report, actual report? Anything can be annexed to the writ petition. And during trial, despite the direction, you just tell the honorable court that what after the direction, what to the SP, what action
Okay,
was
I got it. इसका पूरा evidence करो. If you want to file written note of submission, you can file. I got it. Written note of submission to be filed within a week's time. Within a week time, judgment result. Okay. That पूरा देवो. Writ petition to copy को भी करें तो. Exhibit 6 and 7 both.
7, sir.
One more. DW1. They have examined one DW1.
What?
DW1 evidence has also not been discussed.
Yes.
At all by this trial court.
I know all the accused persons who are of my village residing on so. I know the deceased Parvati, wife of so. She died by hanging in a rope. On hearing shouts of Sanju, sister of the accused Dinabandhu, from their house, when I went there, noticed the deceased was being hanged by a rope. As such, I cut the rope by means of a sickle. As a result, the deceased fell down on her left side. At the time, the deceased arrived, for which I gave her water. Thereafter, some villagers and the accused persons, except accused Dinabandhu, who were harvesting paddy from the nearby field, came to the spot. 10 minutes thereafter, the deceased breathed her last. Since the matter was informed to the Mangalpur PS, the parents of the deceased, in the same day night, police came to the spot and interrogated Swanson. Thereafter, then the dead bodies of the deceased were taken to Jajpur for PM examination. I accompanied the dead body of the deceased to Jajpur, but as Jajpur, as one of the uncle of the deceased told the doctor Jajpur to report that the case is a murder one. The doctor of Jajpur referred the dead body to the deceased of Cuttack SCB Medical College for PM examination. Accused Dinabandhu was present in the service to Swanson. That also explains the
sequence of it.
Well, that is what I beg to submit, that the accused persons have not suppressed anything from their side from the very beginning. It's a case of
Okay, you file a written note of submission.
Yes,
okay.